Mr. McCauley.
Hey, sir.
How are you? Shh. So I have you out here because I have a couple things that have been brought to my attention that are quite concerning. I'm not asking you to say anything. I don't want you to say anything, but I want to put something on your radar. I want to do everything in my power to protect my city, my public, and I'm going to do it in every way that I can. I always give everyone the benefit of the doubt. But from what I understand, state is telling me that you have been allegedly making phone calls or threatening the complaining witness in this case. You're charged with terroristic threat. And I want you to understand that it's a no, don't. I'm not asking much from you. All I'm asking you to do is don't contact this witness. Don't use anyone else to contact this witness. Don't make any threats. I had someone in this very situation not too long ago. I found that they continued to make threats, and I put them in ag seg. I put them in segregation, separation. They literally sit in one room for 23 hours a day, 7 days a week, and they get 1 hour to go out. I don't want to have to do this to you, but if I find that you're threatening the witness in this case, I'm going to have to take drastic measure. And that includes putting you in ag seg. That means they take you out of Gen Pop, put you in this thing, and you're stuck there indefinitely until, I guess, either the case is resolved one way or the other. I also understand that your father is also allegedly as well. He's on bond for murder from what I hear. And if they go up there and they start hooting and hollering up there with the felony judge, it's very possible that they take action as well. Just don't. Life is way too short to spend the next years inside a 6x9 box. It's not worth it. Do you understand?
Yes, sir.
Do you have any questions?
Yes, sir.
Don't make any phone calls. Don't use anyone else. All I'm asking you to do is just don't. You know, if they, from this day forth, if I find that it happens, I will have a hearing to hold you in ag seg. You have to understand every phone call that is made, any correspondence that is sent, it's all recorded for the entire world to see. There are eyes and ears everywhere. Do you understand?
Yes, sir.
Okay. Did you want to add anything?
Yes, Judge. So I've been in contact with the complainant. She has told me that in the past, she has gone to the hospital because of him because he's been physically abusive to her. She thought that he was capable of acting on his threat had the police not arrived when they did. The first time I made contact with her, she told me that she had wanted the case to be dropped. And then the next day she called me again and said that the defendant, the witness on the case, who is the defendant's friend, basically ensured that that's what she had told me, that she had wanted the case dropped. And so they have been making contact with her, Judge, the defendant, the friend, and the defendant's father. The complainant is in fear for her life. She feels like she's being harassed and threatened. He has been in communication with her since being in jail. She has blocked the jail calls now. I advised her to file police reports so that we can get all this on paper because, for defense, defense has certain rights as well, Judge. And so, we want to do this formally. I would ask that given the egregiousness of all this and due to the genuine safety concerns that the complainant has, I would ask the defendant not be released from custody.
So from what I see now, and I'm going to, here, you respond, please.
If I will, Your Honor, right now, he's still currently on bond in this case. And at this point, we have been given no notice of what the actual allegations are. We haven't seen a bond revocation report. We have yet to see any evidence of this other than hearsay from a party that has yet to come to testify to give her own testimony. I believe right now a revocation of bond is improper.
He's right. I know that you're standing up for the complaining witness in this case. I understand, but I have to see, right?
Sure.
And number one, has there been a no contact that's been entered in this case anyways?
There were bond conditions. In the bond conditions, he was supposed to have no contact.
Okay,
But we need a MOA, Judge. There's no MOA in place.
I will grant the order for protection now.
And I've spoken to my client. We're in agreement to that.
So-
That's fine.
Just, you're on notice. Eyes, ears everywhere. This is what we do. I don't want to have to do anything to you. I don't want to have to put you in seg. So please, just don't. And just, like I said, life is not worth spending the next couple years in a box. So you're on bond in this case. I'm not going to revoke your bond now because they've not shown me anything that you have violated other than words, okay? If they show me something, that's different. I'm going to enter in this order for protection now that prohibits you from having contact with her. So don't use anyone else. Do you understand, Mr. McCollum?
Yes, sir.
So this order for protection now,
Yes, it was signed on 11/7.
I know I'm granting a new one so that it extends it for another 61 days. So that Ms. DeVoe is now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Understand, if you continue, it's very possible they file stalking charges on you as well, right? There's a multitude of other charges that can be facing if it continues. You cannot communicate with this person indirectly or in an indirect manner. You cannot use another person to try to communicate with this person. You cannot be in possession of a weapon, go within 200 feet of where she lives or where she works. Just don't communicate. Are we good?
Yes, sir.
Do you have any questions?
Yes, sir.
All right, I'm gonna have you sign this order for protection.
I have a question, Judge, before we, is there a way to attach the father to it as well so that he doesn't have contact or no? I didn't think there was, I just wanted.
So what I had advised and the appropriate way would be go to the felony court,
Yes.
apprise them of what is going on. They can take the measures if they deem appropriate, how to do that. But you need more than just the words, right?
So we should have the jail calls soon, according to my investigator. I spoke to her about it yesterday. Did you want to set it?
So
And
I would like to, at the minimum though, give him the benefit of the doubt, because I've not spoken to him to let him know the consequence of trying to communicate with her. You're on notice now. They want me to put you in separation now. I'm not going to do it. But if after today, December 4th, 2024, if I find that it continues,
Order in the court.
okay? I'm giving you the benefit of the doubt now, but it's not going to happen again.
Thank you, Your Honor.
We good?
Thank you, Your Honor.
Life's not worth a 6x9 box. There's so many other fish in the sea. This is not your problem. You're on probation. That's what's holding you. You know what I mean? Come on, man. Really?
I understand. Your Honor.
Okay.
And at this point, Judge, I believe the only thing I have, at least when I looked yesterday, visible to me is an OR. Can we get a regular reset on this? case?
Yeah, absolutely. So it looks like the felony is set for January 22nd. Whatever you want, it's yours, whatever you need. Yeah. All right, Mr. McCauley, we need you to sign them up and then good luck, okay?
Yes, sir.
All right. Hey, what's up?
Yeah, we'd like to get, had an opportunity to discuss this matter with Attorney Siegler. We would like to get a T-RAS done on Mr. Williams. I think that we're pretty close to getting it worked out. I know, and I heard it loud and clear.
I'm not, the case is 5 years old. He's been MIA for that long. It's, how's that fair for everyone else who
Yeah, I completely understand. Obviously, I've been on the case for about 72 hours at this juncture. I just think in the interest of justice, given what the facts are on this matter, I think there are a lot of mitigating factors in this case that possibly may not necessarily result in a dismissal of the case, Your Honor, but definitely can work in the interest of justice, given the actual facts. It is unfortunate that this case has been floating around for 4.5, 5 years now. But I am.
it's him and its refusal to come and do what he's supposed to do. Have you run an NCIC to see how he's behaved while he's been on bond for this case as well? Has he picked up other new cases as well? Does he have any other DWIs? You know, but he's been MIA for 5 years. That's just,
And at this time, this was the one where I was mentioning those hospital records, and for some reason, we hadn't, for all these years, filed the HIPAA protective order to share those with them, so I was trying to do that and give them a second.
yeah, I'm happy to sign it and give this up, but I mean, for me to give him more time to get ready for, to work a dismissal when he's been gone for 5 years and now he wants more time? Really? I want more hair. Am I gonna get it? I mean, what other, has he picked up any other cases while he's been?
Some home improvement fraud felonies from October of this year, unknown disposition.
He's on bond for felonies now?
Your Honor, just by way of clarification, these are some out-of-state matters. Obviously, this is not the time or space to get into the details of that, but suffice to say, I'm pretty certain those matters are going to be dismissed. Louisiana has some very different rules on just
What is his name again?
Kareem Williams.
Come up, Mr. Williams.
Hurtado Luis.
You're on bond for this DWI. You've been on bond since 2019, and now you've picked up a couple felonies out of state. I don't want you to talk about the case. My only concern is while you're on bond in this case, you're supposed to behave yourself. You're not supposed to pick up any new cases, and you've picked up a couple felonies out of another state. Are we supposed to reward you for picking up new cases? What else has he done, Ms. Ziegler, since 2019? 2 cases, 1 case?
I believe it was just one case from October.
Why should I not revoke his bond and put him in jail now? He's on bond for this case. He's been on bond and he now picked up a felony in another state.
And I do understand that, Your Honor. I think that just in the interest of justice, I think that given the facts, and obviously we're not here to discuss what's going on in Louisiana.
Are you representing him in Louisiana?
I'm not, no, Your Honor, I'm not representing him in Louisiana, but obviously I'm in contact with counsel there. I think without getting into the details of that, Your Honor, I think it's an extraordinarily interesting law that they have, or laws that they have in Louisiana, where what we would consider as a technical civil dispute somehow gets transformed into a criminal matter in Louisiana. Obviously, the French civil law, I don't even attempt to try to understand those rules, but it is more of a civil dispute more than some type of fraud that was taking place in this situation. I think we're very optimistic that that's going to get resolved. Obviously, I've just been on this matter, Your Honor, focusing in on the CWI matter, Your Honor. It was, yes, it was a crash, but the facts as set forth in the incident report, Your Honor, he did not collide with another vehicle. He didn't hit a pole. He didn't hit a tree. Instead, based upon the report, he swerved to avoid another car coming out of a private driveway. So to avoid from hitting that vehicle, he swerved, hit a curb, which resulted in blowing out the tire on his vehicle. The car had other people in the car, and obviously that creates some issues, as Your Honor could imagine. But this was not a DWI case where he's driving down the road 60 miles an hour and crashes into someone or anything in that realm, Your Honor. So for those reasons, I think in the interest of justice, having him to go to jail, not that that's what's on the table right now, but having.
It is on the table now, because he picked up a felony case while he's on bond for a case, right? He's been MIA for 5 years, and now you want some kind of in the interest of justice. The interest of justice is that we protect our county. You're on bond for this case. You've been on bond for 5 years. You've been gone. Now you pick up a felony case. Are we supposed to pat you on the back? No, I'm revoking your bond. I'm taking you into custody. What are we supposed to do? You know, you can't just be gone and then you pick up a felony case in another state. I mean, what are we supposed to do? You know? Really. But you have to understand that actions have consequences, right? You're an adult. Your failure to act, your failure to come, you're picking up a new case. Now, I know that you say it's a civil dispute, but they found enough probable cause and a grand jury indicted you. That's usually between 9 to 12 people that sit, have completely neutral and detached, sit, listen to facts and determine, hey, we think this person may have committed a felony offense.
Which it was original arrest warrant, and it's still, the DA still hasn't accepted charges.
And Your Honor, again, not getting into the details, and it's not, we're not here to try to resolve the Louisiana.
I get it,
And
but
I'm sorry.
go
No,
ahead.
Your Honor, and I'm just, let me suggest it, Your Honor. What happens in Louisiana is this. There is a civil dispute between the parties, what we would call a civil dispute. And as a result, in Texas, what we would do in the event if a contractor or subcontractor is not paid, we place a lien on someone's property. In Louisiana, if that same transaction happens, the homeowner, now obviously there would be consequences, and may be consequences for that homeowner, can call the DA and say, no, this guy ripped me off. Notwithstanding the fact they owe him money, this guy ripped me off. And if the DA there,
Because I've had 2 people that have done that to me.
well, Your Honor, over there, Your Honor, over there, that it turns into a criminal matter. So again, we think it's going to get wiped away. I know we are this close to getting this matter resolved. And I think in all respect to the court, all respect to the bench, Your Honor, not being here for 5 years is a major issue. This matter should have been resolved a long time ago. Had I been brought in 6 months ago, it would have been resolved 6 months ago, Your Honor. We're just asking that, one, if there could be a level of grace and mercy extended to Mr. Williams at this today, I think we could get the matter resolved today, Your Honor. Obviously, I haven't had an opportunity to look at the medical records. I haven't had an opportunity. I haven't had more than 30 minutes to even examine the record.
And you know, I'm sorry that you're being placed into this precarious position now. And the facts are what they are, right? If we could make our own facts, we would all win. But at times, the bill comes due. That is today. But if you think that you can just continue to get away, jump 5 years, come back, and while you're out there, you pick up a felony case as well. I can't because I would be telling you that behavior is okay, and it's not. If you guys are able to, work something out, by all means, I'm okay with that. But I can't in good conscience, when he's been gone for 5 years, he picked up a felony, whether it's in Abu Dhabi, whether it's in Alabama, Oklahoma, he's hopscotching states, but he goes with you. If you want to work something out, I'm happy to whatever you guys want to do, but it's only fair, it really. But like I said, if you guys work something out, I'm happy to entertain whatever you guys want to do. But you guys talk, don't
Understand.
not here. He's gonna take him back. I'm gonna let you guys talk, see what you want to do. I'm all ears. I'm always open to anything else, but the bill comes due. All right. Take your time. There's no rush.
Yeah, that revision is what I'm thinking right now. We can talk more.